Welcome back to Credit Learning. In this video, we want to talk about the fresh lawsuit that was dropped on Experian by the CFPB. The CFPB supervises consumer reporting agencies and credit bureaus and enforces the FCRA and many of the consumer laws like the Equal Credit Opportunity Act, Fair Credit Billing Act, Truth in Lending Act, the FDCPA, among others, Truth in Saving Act, and among others. The credit bureaus have been behaving badly for as long as they exist. From time to time, the government steps in and carry lawsuits against them. This usually was done by the FPC, but now the CFPB, as a result of the Dodd-Frank Act, assumes some of the responsibilities that the FPC, that are enforcing arm, had. Sometimes both the FPC and the CFPB combine, and some of the issues that they basically enforce against corporations within the financial sector. Now, there are several important things concerning the lawsuit that they brought against Experian, and there are several ways how the lawsuit can be leveraged. But it can be leveraged only if you really understand the FCRA, because that is where the case is derived from, among other laws, because once the FCRA comes into play, UDAPs come into play. What is UDAPs? Unfair and Deceptive Act that the FPC enforces under Section 5 of the FPC Act, and the CFPB also enforces under Unfair and Deceptive Act. Once you violate the FCRA, you automatically violate the Unfair and Deceptive Act. But what ends up happens, unfair and deceptive practices can only be enforced by the government agencies, whether federal and state. So once you violate the FCRA, you automatically violate Section 5 of the FPC Act. So it's under these, they basically bring the lawsuit against Experian. This lawsuit will eventually more likely lead to a consent decree. Consent decree is where both Experian and them have some negotiation about the terms of the punishment, and there will be also monetary settlement once they can prove the claims that they bring about. And they usually don't lose these cases that easily, because they would have gathered a huge amount of information that they base on, because in the lawsuit they lay out and list specific time period where Experian wasn't compliant with certain responsibility, and describe in detail the behavior patterns of Experian, which means they have evidence of this, because they also supervise the credit bureaus on an annual basis and publish the findings of their supervision regularly. Plus, you have other watchdog groups that monitors them, that publishes stuff a lot of times. And sometimes when you see, you might not notice, but let me drop some information on you here. A lot of times when you see the CFP publishes an advisory opinion, a lot of the finding that comes out of those sometimes comes from their supervisory work, and a lot of time comes from the scholarship, the credit scholarship and debt scholarship, legal scholarship of the watchdog groups. And the CFPB lawyers read these publications and then do their checkup on it, because I am aware of several of these publications that publish major findings prior to the CFPB finding, because this that they find Experian guilty of. For more than 2 decades, legal scholarship has been publishing these same findings on it, and some of the advisory opinions that are issued by the CFPB from time to time draw on some of these legal works that was published prior by watchdog groups consumer protection agent, consumer protection advocates, I should say. So I just want to cover some of the things that they find Experian guilty of and how you can leverage some of them in your disputes if you are credit repair companies or if you are working on your own credit. One of the things that they find Experian guilty of is how Experian process the disputes that they actually process over the time period that the case is based on. And it is found that Experian has not been processing the disputes. They are conducting sham disputes. They are not reinvestigating matters. And some things they outrightly don't even investigate. For example, odd inquiries. If you don't put certain language in your letter regarding odd inquiries, that the odd inquiries are fraud or something like that, Experian ignore your dispute and don't conduct an investigation. Once, and this is where I said your knowledge of the FCRA must come into play. Because if you understand the section of the FCRA that governs odd inquiry, you would use the language. Once you use that language, it should trigger investigation. Experian ignore that kind of language and push you to claim that it is fraud and stuff like that before they actually investigate it. So as a result of that, they basically don't investigate the odd inquiry and allow the odd inquiry to remain in consumer credit report even when they were not legitimate and no authorization was given for whoever to pull the consumer's credit to pull it. So that section of the FCRA, when you're dealing with odd inquiries, you can leverage this complaint now to push Experian to prove that you actually have given consent to, because the FCRA has specific requirements where this is concerned. Another issue that Experian actually is found guilty of, they are not complying with the 30-day requirement where they should complete investigation. And I had this suspect for a while because when, for example, you do a CFPB complaint, almost all of the other two big three will come back within the 30-day time frame sometime and give you the result. Experian is the only one of your case still open when the 30-day pass. And I've been noticing this for months, and I'm saying, but Experian is not responding to the investigation when we submit them and post the result on the CFPB website. So what Experian have been doing is that Experian have been deleting the items in several cases when the dispute is filed, and then act like they comply with the 30-day requirement of the FCRA that the disputing process must be completed. And then what Experian do now, go ahead and run the investigation, the sham investigation after the 30-day period, and then bring back the items that they deleted and add it back to the credit report. The FCRA has specific information and procedures that must be followed when that takes place, and Experian was not doing that. Then, in a similar instance, Experian was deleting accounts that was found to meet the requirements under the FCRA to be deleted. And then what happened, a debt buyer might actually buy the debt from a previous debt buyer who furnishes it and come back to the credit bureaus, and Experian would put on an account when the account should not be reinserted in your credit report unless there was certain procedures that was followed, and Experian was not following those procedures. And what should be done in regards to the SCRA, where this specific kind of things, the consumer must be given certain kind of information And Experian was not doing that. The other thing that Experian was found guilty of or to be doing is that when investigations are done, they should provide certain specific information and certain specific details to the consumer about the nature of the investigation. Experian was not doing that and presenting confusing letters. In addition to that, Experian also must provide you when you ask them certain specific information, like for example, method of verification, and they should give you certain specific information and tell you the name of the creditor and all kind of the furniture, I should say, and certain other stuff that goes with that. I'm not gonna get into all the details of this. You wanna get this kind of information? My credit repair series that deal with specific kind of account walk you through all of these information, reinserted account, hard inquiries, and all of that. My books walk you through that. So if you really want FCRA knowledge on this, if you're not familiar with what the FCRA require, get my books at tyrannycreditproducts.com, and you will see me walk you through the law, what must be done, and the letters are already there for you with the processes that should be followed step by step. Let me continue. So what Experian was doing is that they're not giving you that sort of information that they should give you in the results of the dispute. So that is one of the things that they were also doing. In addition to that, Experian also, in addition to that, Experian also disadvantage consumers when they use Experian online website or their app to do the disputes. When you do a dispute over the phone or mail it in, you have more options and you have a better chance of accurate information concerning the nature of your dispute be transmitted to the furniture. Experian basically disadvantage you when you use their online portal and their online platform. So that information tell you that if you want to have a better shot at getting results, don't use the online portal because you're going to be at a disadvantage. So that is one of the things that they are found guilty of. Also, the other thing, the FCRA requires you, the credit bureaus, to forward your information in terms of documents that you submit with your dispute to the furnisher. Experian have been not furnishing it, or if they do, they minimize what they furnish. They only submit the ACDV form that they use to process it, and the information on that is limited. It's one page. So these are some of the major findings that are grounded are the substance of the complaint against Experian. Once you know these things, if you're not familiar with the FCRA, you're not gonna really realize how you are being violated and how you need to attack this. You understand? If you want to learn the FCRA, coming very soon is my university, Tyranny University. You can sign up and get on the waiting list for when we drop it in a few weeks. We will be doing that in this. We will be teaching all the consumer laws that have to do with credit and your rights and mastering the FCRA. So if you're not familiar with the FCRA, you're not going to realize how Experian is violating you and what you should do when they violate you. And this complaint strengthens that, but you're not going to get the meat of the complaint if you're not really familiar with the FCRA. The CFPB lay out the requirements of the FCRA, but hearing it and knowing it is two different things, because if you don't understand the FCRA, it's gonna be a bit tedious for you to understand um, what the violation is and what must be done, and so on and so forth. So this is the major findings and the bomb that the CFPB dropped at the beginning of 2025. You can use this information to leverage your disputes, your disputing order inquiry. You use the FCRA requirement, and then you basically could add to it that, listen, I have been disputing this order inquiry accurate, and you have not been giving me the result that is required based on FCRA, and you are doing exactly what the CFPB said that you have been doing to consumer, and I'm gonna make sure I pursue highlighting this and showing that you are continuing stuff like that. You can add to your letter. In terms of the reinsertion of account, you can add procedures that must be followed with the reinsertion, and that you have been a victim of what their common practice, so on and so forth. So that's how you can leverage the law. But you have to actually know the FCRA requirement to really be on point in your language, and pressing them and pointing out their errors. Outside of that, you can have a general knowledge, but really knowing the law will allow you to see the gems that are in the complaint, and you will basically learn more. All right. So I just want to give this update in regards to what the CFPB began 2025 with, dropping a big lawsuit against Experian. I hope this was helpful. I just want to give you some insight in what is in the case. Peace.